an application in the matter of Patourel and BT Group Plc and another.
Mr. Kreisberger, just before you start, a couple of things.
Sorry, the audio isn't coming through. Could you speak again, sir? I'm very sorry.
Yes, I was saying to Ms. Kreisberger, before you start, a couple of things. First, you may have seen 3 people just come into court. They're French avocats being introduced to the mysteries of English competition litigation. Secondly, in terms of organising this morning, we have in mind, Ms. Kreisberger, that you need to sit down by 11:55. Mr. Beard needs to sit down by 12:45, giving you 15 minutes to reply. And as you may infer from that, we don't envisage giving judgment today. It will be a reserved judgment.
I'm very grateful for that.
Could you speak into the microphone, please?
I think it's not designed for someone of my height. Is that the best I can do?
Downward adjustment is required.
That seems more appropriate. Is that working?
Thank you so much.
Thank you, my lord. I, as you know, appear for the class with Mr. Spitz, Mr. Armitage and Mr. Barry. And Mr. Beard appears for BT with Ms. Love and Miss Ewan. Just in terms of housekeeping, there are 7 volumes of the core bundle and 3 volumes of the authorities bundle. Could I just ask whether your lordships are working from the electronic bundles or not, just for references?
I'm working in hard copy. I don't know what my lord is doing.
I'll give the hard copy references in that case.
So we're delighted to have received so many bundles.
I apologise for the volume for a half-day hearing. There were discussions about that, as your lordship might imagine. Maybe something to come back to on costs. With that, if I may, with your lordship's permission, begin with ground 1. I'll be addressing the first 3 grounds. I intend to spend a bit more time on ground 1 than the other 2 grounds, subject, of course, to your lordship's question. My submission is that ground 1 has a real prospect of success because the CAT erred in law in its treatment of the evidence before it on the common costs of supplying SFB services. And I will develop that submission in 4 parts. First, I'll set out 3 key legal missteps by the CAT. Secondly, I'll show your lordships how the CAT erred in its evaluation of the evidence following on from those legal errors. Thirdly, I'll respond to BT's arguments that the fault lies with the class representative for not suggesting to BT that it conduct a cost allocation exercise. And my Lord Justice Green's question as to how this came up as a matter of case management. We've, of course, addressed these points in written submissions, and I'll develop them a little further today. And then finally, I'll make just a brief submission on a phobia on adverse inferences. So, beginning with part 1 on the 3 key legal errors. If this court grants permission, we'll say that there were 3 distinct legal missteps. And it may be helpful if your lordships have to hand the judgment, which is at volume 1, tab 9, page 130. Now, the first error, we say with respect, is that the CAT failed even to acknowledge the existence of the Sainsbury's principle, which the class representative had invoked at trial. including by reference to your lordship's judgment in Royal Mail and DAF, which was handed down during that trial. As your lordships will have seen, and as my Lord Justice Green knows well, that is the principle that a defendant in BT's position comes under a heavy evidential burden to produce evidence about its costs, which is exclusively in its hands. Now, that principle features nowhere in the judgment. At paragraph 665, page 290, the paginated fund group, page 290. There, the CAT rejects the class representative submission on the adverse inference, you'll see, in a single sentence, and with no reference to the legal principle which underpins that submission. Now, it's only in its ex post facto reasoning in the PTA order, just for your note, that's volume 2, tab 11, 440. It's only there that the CAT refers to the principle after the judgment and to those authorities.
Can you just explain to us what, in your view, the principle is? In DAF, we were dealing with circumstances where defendant, for pretty much manifestly strategic reasons, declined to put any evidence in. Here we have Dr. Jenkins' report as a substitute for BT generating its own data. So it's not as if we had a data gap or an evidence gap. What we had was evidence which you say was defective and which the CAT found some fault with. And that evidence was subject to the normal iterative process for dealing with experts' reports. So is it really a Sainsbury's type of case? It's just that you didn't like the evidence which was put in, you attacked it to a degree the CAT agreed, but then decided it didn't need to draw adverse inferences.
Yes, that's quite right. And the reason I say this does engage the Sainsbury's principle, is that the rationale for that principle is that the defendant or claimant in a parcel case comes under that heavy evidential burden because it holds the cost data. Now, in this case, BT didn't produce any cost data and didn't produce any evidence of fact, for instance, on drivers of common costs that would elucidate the question. So bringing forward an external expert to give an opinion without any factual basis, completely untethered to facts, doesn't comply with the raison d'etre of the Sainsbury's principle, which is, well, you're the party that holds the cost data, you should produce it.
And honestly, let's assume that's correct. What are the consequences? Do you say the CAT should have adopted a punitive adverse inference, or what should it have done? The CAT were critical of your own expert for not providing an answer to where the common costs figure should lie. What do you say the CAT should have done? Because it did do something. It took the lower end of Dr. Jenkins' report and then discounted it. You say not enough.
Yes.
But it did do something. It doesn't say it couldn't cope.
Well, I'd make 2 points in response to that. It did something, but that which it did was irrational.
Okay, that's your second ground. That's ground
So
2.
taking a lower, well, that applies to ground 1 and ground 2. Ground 1 concerns the size of the common costs.
Yep.
Ground 2 is the allocation to SFV. And on both counts, and I will, if there's time, take your lordship to some of the passages in the judgment, the CAT said this evidence is not fit for purpose,
No.
it's not good enough.
Let's assume, set that aside. What I'm really interested in,
Yes.
what you say the CAT should have done, because it was critical of BT for not generating this data, which it said it could have done within
Yes.
reasonable cost and reasonable time. That's what the CAT found. It didn't. But the CAT then went through its own analysis and from its own perspective appeared to have coped, if I can put it that way. So I'm asking you, what should the CAT have done,
Yes.
even though it was critical of BT? It didn't accept Dr. Jenkins' report in all respects. or might say to a limited degree, it took account of it, and it formed its own conclusion. What's wrong with that?
Yes, so what we say the CAT should have done is it should have considered, first of all, why has BT chosen not to produce hard data on its indirect costs, or even factual evidence which would illuminate questions about the size of those costs.
Okay, I'm going to press you again. Let's
That
assume
would
you're
be-
right. Let's assume that the CAT was critical and concluded it was tactical.
Yes.
Again, then what?
Yes, and your lordship has just preempted my next point. Was it a strategic
Let's
decision?
assume it was.
Let's assume it was. Well, in that case, drilling down, the specific question which the CAT should have next considered was, is the reason for that strategic decision that the opinion evidence, floating untethered from facts, produces larger numbers than a factually based assessment of costs would have produced, whether that's whatever level of fact that might be, all the way down to the actual data. So it should have considered, essentially, was this a tactic to inflate the common costs and thereby inflate the benchmark and reduce the excess?
Yep.
Now, it never considered that question, but had it done so,
Do you know it didn't consider the question?
I'm sorry, Your Lordship, I simply mean on the face of the judgment.
No
rather
mention
than-
of the point.
There's no mention of it. You're quite right to pick me up on that. They don't include that question in the reasoning.
Yeah.
So it's an absence of reasoning, the CAT had expressed some real surprise about the absence of this evidence during the trial, and we've given you some of those references. But had they concluded that that's why it was done, to get the number up, essentially, then the CAT should have said, well, the adverse inference is that we do not rely on Dr. Jenkins' evidence
At all.
at all.
Can I just pursue that a moment? As you say, this was something that was aired during the hearing. There's also a principle that when we look at judgments, perhaps especially really long judgments, we don't assume that the judge or tribunal hasn't taken something into account merely because it isn't in there. It'd be very surprising, wouldn't it, if the CAT hadn't had these sorts of points in mind? And if it did, you're quarrelling with their evaluation of the significance of them.
So it is surprising, given that a central plank of the class representatives' submissions was that the Jenkins opinion evidence was not meaningful, was not informative, because it involved an expert in economics from outside the business using subjective judgment, staying with ground one, using subjective judgment to ascribe probabilities as to the size of the costs. So it was a key plank of the class representatives' case that was fundamentally not a useful exercise. In that case, it's surprising not to have a response from the CAT that says, let me put it this way, this would be a much harder problem had the CAT said, for some reason, Dr. Jenkins has some particular insight into these costs and therefore we place heavy weight on her opinion. That couldn't be further removed from the trenchant criticisms in the judgment. Having made those criticisms, the CAT then stops before adopting the next logical step, which is...
What if that's fair? I mean, it's quite a short paragraph, but 816 seems to do that. There are not many people in this country will have read this judgment from A to Z. We might be, in this court, the only people who have and ever will.
Many happy hours. Wild
Many
away,
hours.
Yes. Well, what I would say about that is that at 816, and as I say, I would trespass on your time a little further to give you some other references, but they say at 816 that her evidence cannot be taken as reliably established, and there's a significant risk that they've been overstated. Now, the CAT's solution, somewhat implicit, but one sees what they do at those central paragraphs of 903 to 905, which contains the operative reasoning. But their solution is to draw a little less poisoned water from the well. And we say, well, that's not a cure, that doesn't avoid sickness. You can't take something that's not reliable and adjust it down. And if I might just...
I'll stop you there.
Yes.
You're not going to get away with that.
Yes.
I'm very interested that you say that no weight whatsoever should be given to the report, because as I read the judgment, that's not the way the CAT saw it. The CAT absolutely accepted there were criticisms to be applied, that the baseline for Dr. Jenkins' report of 262 million was not reliable, and it therefore had to come to its own judgment as to how far below that floor threshold it discounted the figure to get to its allocation for common costs, and it went down to 250. So it isn't the issue, can the CAT cope? Not, is the CAT cross with one of the parties, but does that failure by BT mean that the CAT is disabled from coming to a fair, in its own mind, conclusion? Or is your view that it's a punitive consequence for misconduct? I understand your analysis to be it's effectively punitive.
Well, let me put it this way. It's a feature of this case that the sort of core irony at the heart of this case is that the class representative was the only party before the CAT to rely on BT actual cost data audited, prepared by BT according to allocations under regulatory obligations. That was the 2009 RFS. So the CAT had before it audited data from BT from a period that was 6 years before the start of the claim period. And one sees, and I can take your lordships through, that the CAT takes the curious step of endorsing, that's not the curious part, the CAT endorses the RFS in multiple paragraphs and agrees that this is actual cost data, and rejected out of hand BT's refrain that because it's from an earlier period it's not actual data. The CAT rejects that, upholds the RFS as a reasonable approach, and then places no reliance on it whatsoever. It doesn't even run a cross-check of its own assessment that you see at paragraphs from 903 and following. It doesn't run the obvious sense check, which would be to compare them to the indirect costs. They say, oh, well, Mr. Duckworth didn't split out common costs. Well, that's because that's the way BT approached the allocation. And that needn't have hampered the CAT because there was a figure for indirect costs. It just wasn't broken down, disaggregated beyond that. And yet the CAT, strangely, never conducts that exercise.
This is a rationality argument. I mean, look, I think you need to approach it in stages. I think your first point is, as much as anything, a point of principle. Let's assume, for the sake of argument, the CAT was critical of BT, did consider that it failed to generate the data for strategic reasons. I mean, I want you to address what happened in case management at some point, but let's assume that. And as a matter of principle, the question then is, does the CAT apply effectively a punitive approach to the evidence, or does it ask itself, because of this failure, can we cope or can't we? And if we can cope, then we just factor in that failure, perhaps erring on the side of caution, giving you the benefit of the doubt, but we come to the best conclusion we feel we properly can do. That's what BT says happened. That even if you assume there was a failure, the CAT was still able to cope and did so.
So it is, of course, my submission that it was irrational, but I would say also it was an error of law, because taking it in stages, what the CAT should have done is recognised that BT was under a heavy evidential burden to produce evidence on its cost, because that data was exclusively in its hands, and that should have been its point of departure. BT had not discharged that burden by bringing in an expert from outside and also rejecting out of hand its own audited statement, which is quite puzzling.
Assume all that in your favour.
Yes.
I'm still on the then what. So, if your submission is they should have ignored Dr. Jenkins' report on common costs altogether and effectively treated the figure as zero, I think that manifestly wasn't the CAT's point of view. They thought it was not as high as 250, but as 262, but below that somewhere. And so the question is, if there's an adverse inference to be drawn, is it punitive such that the CAT should have gone to, say, 0 or 5 or 10? Or should it ask itself, can we cope? If it can cope, it just does the best it can. If it finds that it's not drawing a sufficient adverse interest, it adjusts in your favour. What I'm interested in is what the consequence is if you're right.
If I might put it this way, I wouldn't characterise what the CAT did as a coping mechanism, because what the CAT did was acknowledge the problems in the Jenkins evidence, but then proceed to rely on that evidence alone, just at the lower end of that evidence. Now I say that's an error of law, because how is the tribunal to meaningfully cope with evidence that it agrees is strategically designed to produce an inflated figure and therefore an inflated benchmark? There isn't a meaningful, rigorous coping mechanism that cures the problem.
Mm-hmm. So you're not saying it's a punitive?
Yes.
You're not saying it's a punitive doctrine, the doctrine of an adverse inference. It's really about ensuring fairness of evidence.
Yes, it's ensuring that what is described as a heavy evidential burden, a rather emphatic concept, the heavy evidential burden, it must have bite. Now, what I am certainly not submitting, and it may be helpful to just clarify at the outset, I'm not suggesting that Sainsbury's always leads to an automatic drawing of an adverse inference wherever there's a gap. That couldn't possibly be the case. That would be to fetter the CAT's discretion unreasonably. But in these circumstances, the CAT should have found that failure to discharge the evidential burden was significant, given that its view of the substitute evidence for hard data and factual evidence was deeply, profoundly problematic. And that's why it should have drawn an adverse inference on these facts. This is not a case and I think the recent Phones for You judgment from this court is an example of the other type of case just handed down. This is not a case where we're suggesting that an adverse inference should have been drawn which contradicts the cat's actual view of the evidence which was before it. That, I think, is not a... The Sainsbury's principle doesn't doesn't necessitate the drawing of an adverse inference where the cat says, well, I have this evidence available to me and I find it compelling. I'm certainly not going to draw an adverse inference which undercuts my conclusion. But this is not that case, because there were so many problems with the opinion evidence. And coming back to your lordship's first question, this is a gap because it's not appropriate when you are the firm that has produced a set of accounts in 2009 that do the job, do the trick, and has the wherewithal, as the cat found, to conduct a contemporaneous bespoke exercise for the trial. It's not reasonable for that firm to rely only on opinion evidence. That is a gap. That is a fundamental lacuna that can't be plugged by asking the opinion of someone from outside the business without any insights from the business. So when I submit that the adverse inference should have been drawn, the inference would have been, well, I have this opinion evidence, I consider it to be strategic and therefore doesn't illuminate the question of common costs. Whereas, on the other hand, I do have the 2009 RFS, which has been uprated by the class representatives expert, but it is uprating of BT produced data. It's a highly unusual feature of this case that we were the party relying on the BT data.
Yeah, no, I understand that.
And BT rejected it.
You just used the expression, BT's approach was strategic and Dr. Jenkins' report does not illuminate. If you read the cat's judgment, it may be more fair to say does not illuminate to a degree. I mean, the cat, one reading of the judgment might be that the cat certainly had lots of criticisms of the approach, but did not consider that it was to be rejected altogether. I mean, it explains its approach in paras 37 and 38 to both experts. I don't think it anywhere says it rejects Dr. Jenkins altogether. It might be said that that's why they felt able to discount from the lower baseline, or the lower threshold, as opposed to the baseline of, what was it, 360 odd, 390.
Yes.
So at the baseline 390, lower threshold 262,
Yes.
cat went to 250.
Yes.
That takes account of the criticisms. Maybe that is an adverse inference which is being drawn in action.
Could I perhaps just show your lordship a couple of key passages where the cat does address, I'm staying for now with ground one, so
yes.
that's the size of the common cost. I'll
yes.
come on to the SAC-COMB. But if I could ask you to turn up paragraph 794 of the judgment,
Yes.
which is at 316.
Yep.
Sorry, I've in fact got the wrong page open.
That's on 237
Yes.
of my bundle at least.
So
794.
794 is where the cat said, more telling, however, is the class representative's related point,
Yeah.
which is that however useful her own exercise of judgment may have been, she could and should have been assisted by BT itself in performing this exercise, there is no reason to think that BT could not have provided input as to the status of the cost line.
Yep.
By reference to detailed descriptions of what these costs were actually for, which Mr. Duckworth describes as the missing quantitative evidence. So again, that raises the question, given that she wasn't informed by that data, and the CAT found in turn that she should have been so informed,
Yes.
simply performing a minor adjustment doesn't cure the problem. And as a matter of policy, it creates an unfortunate incentive for the defendant firm that can not produce, take the active decision not to produce any of that evidence that the CAT contemplates there.
It's a question of incentives of any relevance. I mean, that sounds like a policy consideration. What the CAT had to decide was what was the position in this case on the evidence.
Well, I
and
think
I'm
it's-
not sure why incentives should matter.
Well, I think it's a relevant ramification of the judgment in the approach in the judgment in competition law cases. And really that's why the Sainsbury's principle, I would suggest, is articulated in the way that it is.
Well, is it a matter of incentives, the Sainsbury's principle, or a matter of proof? I mean, a matter of application of common sense, really,
Of course, your lordship.
to finding facts.
Yes, of course, your lordship is right. But when I use the term policy, it's probably more accurate to say the effectiveness of the prohibition on unfair pricing. Because it would undermine the effectiveness of that prohibition. That's a statutory prohibition in Section 18. If a defendant firm, which is under an evidential burden, not only under Sainsbury's, but under your lordship's judgment in Phenatoin and liothyronine, if a defendant firm can simply not produce data, which the CAT says it could have produced, then, as I say, the statutory prohibition is potentially denuded of effect.
But only if the CAT can't cope, which is I wonder whether it all boils down to, on the facts, did the CAT itself consider that it was able to cope? In other words, apply an appropriate adjustment, which it felt comfortable with, subject to your arguments on rationality, set those aside for a moment. Just wondering if it just all boils down to whether the CAT felt able to cope, notwithstanding the criticisms, taking them on board.
I understand your lordship's point, and I will set aside rationality, but it's paradoxical. It's paradoxical reasoning to say, here is the data which would have actually done the job of allocation. That data...
That's the RFS data.
That's the RFS or a bespoke exercise as well, which the CAT said could have been done.
Yeah.
And that data would give an accurate measure of common costs. I should add as well, just so your lordships have the point, the class representative's position was that common costs are essentially insignificant. And this was really a fabricated, inflated set of costs, which BT was arguing for, yet with no factual underpinning. And that's really the problem. So when I say no reliance should be placed on it, that is my submission in these circumstances where the CAT had the benefit of the RFS, which split out indirect costs.
But the CAT did reject Mr. Duckworth's evidence on that. I mean, there's a paragraph, I can't remember the number, but they said they rejected the argument they were very low, which was Mr. Duckworth's analysis.
Yes, it's a strange one, because if we go through, they were very positive about both the RFS and the uprating. Would it be helpful to start with that, or just following on from my point about Dr. Jenkins' evidence, if I could just show you 764, and then I'll come back, if I may, to Mr. Duckworth in the RFX. That's on page 310 of the bundle.
Yep.
So in the prior paragraph, you see the view that Mr. Parker's view that common costs were not in reality significant and should not be so, and Mr. Duckworth agreed. And the cat said, obviously, Dr. Jenkins disagrees in the sense that her figures suggest very significant common costs, both in relation to BT Consumer and as allocated by her to SFB. There is her reliance on the VULA margin statement and TSO charges and her analysis of the descriptors. That analysis is not, however, as persuasive in the present context as direct and detailed evidence from BT on the size of BT's common costs, which was not adduced, would have been. You say, well, again, one comes back to the heavy evidential burden to produce the data. That data was not adduced and would have been persuasive. It's a misstep to then say, but we'll fall back on the opinion evidence, given the absence of fact.
So should the cats have discounted common costs entirely?
Well, they had the RFS numbers, and you can see them at 557, if that's helpful, which give the indirect costs. And so it's not a case of, I've got the internal page numbering as 138.
Yes.
In the bundle it's 267.
Yep.
And so if you look at B, cost of sales was essentially agreed. B, you see the class representatives' figures for each of the years in the claim period. And that's the non-network costs per line. And that is the indirect costs, both incremental and common. So it's not the case that the CAT would be discounting common costs. It would just be using the figure in the RFS, which doesn't split them out from incremental indirect costs.
And just, this isn't ultimately significant, I suspect, but suppose you get permission to appeal, suppose you succeed in the appeal, do you then have to have a retrial?
I think I may need just take instruction, but it is right that this judgment captures the RFS evidence. If Dr. Jenkins' evidence, the opinion evidence, falls away, then there is the evidence from the RFS. So
I suppose there would be a number of options. If it was that clear and we could adjust on the basis of given facts, we could do that. Alternatively, you could ask the CAT to reconsider such part of its judgment as we had identified was erroneous and see whether or not it adjusted its conclusion.
Yes.
But I mean, I'm just wondering, the way in which we're expressing the debate, sounds very much like a question of evaluation. I'm just looking at 777, which is effectively saying the plague on both of your houses, we're going to find our own way through.
Yes, well, that is curious, and my submission on that.
Curious or not, it may be a question of evaluation of fact.
Well, there is a rationality point here,
Yep.
which is when one goes through the prior passages, there is a fundamental disconnect between the CAT's reasoning, which endorses the RFS, endorses the uprating, and then there's the oddity of a conclusion which doesn't follow from its prior reasons. There's an absolute disconnect. In fact, the CAT seems to come up with some evidence of its own. And perhaps if we go through that, but it is a curious feature of this judgment because the conclusions expressed by the CAT aren't supported by the prior paragraphs in the judgment. So if we have a look at what the CAT says about Duckworth, starting with paragraph 676 on internal page 165. That's 292 of the bundle. It's
Yeah.
actually internal page 163. The CAT says this. Subject to the separate point about the particular context of the RFS, it's about 5 lines up from the end, dealt with in paragraph 692 to 694. I'll show you those paragraphs. It's very hard to see why this particular manifestation of an FAC, carried out by BT itself in considerable detail and accompanied by an auditor's opinion, should not be considered as at least an appropriate method of allocating common costs. And just while we're in this paragraph, I just note that the CAT says further up, and it's something that it observes you will have seen in multiple places. This is an example of where BT could have adduced evidence on the point had it wished to do so, but it did not.
Well, for there, just worth reading the final 2 sentences.
It's about flexibility, not the size of common costs. Now, if we then go to the paragraph that the CAT cross refers to there, 692 to 693, and if I might just read those couple of passages in full under the heading Regulatory Purpose of the RFS. The second point, although it was not clear by the end of the trial to what extent it was still pursued, concerns the purpose of the RFS. Of course, it was required by Ofcom in the exercise of its statutory powers and on the basis that BT had significant market power. It was also in a context where BT was still prevented from offering bundles, although that was about to change. However, we do not see that this context itself rules out the RFS methodology. After all, BT chose the particular attribution methodologies used, which in any case could hardly be described as controversial or arbitrary, i.e. a fact model, and in relation to indirect costs, the application of the principle of cost causality, with the remainder of the costs allocated on a fair basis. So that comes back to the indirect costs in the RFS. 693, yet again, if BT had wished to adduce particular evidence to show how the output of the RFS was specifically inappropriate to be used as a template for pricing in this context, it could have done so. It did not. So the prior passage that I took you to refers to the separate point about the context of the RFS. So you see the cross-reference is supporting the point made in this paragraph. And then finally, the last one I would take your lordships to is 754 on page 178 of the internal numbering. BT says that an important defect of the RFS in this context is that the methodologies used in the RFS were not fixed in stone and could be changed. That's correct, although it was not suggested by BT. that the allocation principles of cost causality for incremental costs and fairness for common costs had actually changed in the course of the RFSs, or would have done so had they continued. It was also said here that the allocation of costs according to such principles involved an exercise of judgment. That, of course, is true, but if it's exercised appropriately and in accordance with settled principles and by BT itself and its auditors, we do not think that this is a reason to deprive the RFS model of force going forwards. And yet that's exactly what the CAT did ultimately do.
What about 778 to 780? It's got 80 paragraphs worth of analysis of the strengths and weaknesses of RFS. You get a conclusion at 778 to 780, which says we don't preclude it, but we don't think it's entirely reliable. We now go on to consider how it interplays with Dr. Jenkins' report before we come to our conclusion as to where we strike the balance between the two. Again, what's wrong with that?
Well, if we go, if one looks at those passages, in fact, it all points one way until the very end. Very strange, because as the CAT observes, these principles were adopted in the RFS, were adopted by BT itself. And yet BT was the party rejecting the RFS out of hand, not just the uprating. In fact, it said it wasn't actual costs.
The CAT did reject BT's argument on RFS.
And it did. So then how is it that the CAT didn't then place reliance on the figures in the RFS? And I'll show you what the CAT did say.
That 779, where it identified the three weaknesses in RFS.
Yes, so if I could take it in stages, just perhaps for your note, there's paragraph 700. That's where the CAT rejects BT's attack on the RFS as not using actual data. And they say from BT's perspective, it's perfectly true that Dr. Jenkins used actual cost data for the relevant period, but at a much more general level, namely BT consumer, of which SFV services formed a relatively modest part, something like 18%. The whole question was then how to extrapolate the relevant costs for SFV services. On the other hand, from the CR's perspective, his starting point was a set of actual costs for BT voice services in 2009, i.e. from the relevant market, but they had to be uprated. It's very hard to see why the former method is permissible, but the latter is not. So they reject the attack on the RFS.
But you'll see where we're coming from. And when I look at 779, whether you agree with it or not, it's balanced. Look at the pros and cons. They addressed the pros and cons of RFS. They accepted it was relevant, rejecting BT's argument. They modified their conclusion by reference to the fact that the data was historical, that the CPS index may have underestimated costs, and that it had no flexibility built into it. So 3 reasons why they thought RFS had to be tempered in terms of the weight they attached to it. Again, we've got to ask ourselves whether that's in any way an issue of law. But just looking at the approach, it doesn't matter whether we agree with it or not, it's the approach adopted to that evidence. It's not black and white, it was an exercise of judgment, was it not?
So, if I might make a couple of points in response to that, I would distinguish between the legal errors committed by the CAT and the evaluation of the evidence which is infected by those legal errors. So just to summarise, the legal errors were the CAT missed the Sainsbury's principle.
I mean, I see how that works in principle.
So they didn't acknowledge it.
Yeah.
That meant that they inverted the burden. So that's at judgment 665, internal page 159. And in that paragraph, the CAT places the burden only on the class representative. It says the CR has 666.
Sorry, I must be. It's,
Yes, this observation recognises, therefore, that the CR has the burden of proof.
and I think I'm reading the wrong bit. Whereabouts?
Oh,
in
I'm
the-
so sorry. Paragraph 665.
Yep.
In the clause bundle,
Yeah,
that's
oh, I see, yes.
290.
Yes, I've got the sentence.
So
In terms of legal burden, that's right.
that's
isn't it?
right. That's right, but it elides, it fails to distinguish between the legal and the evidential burden. It doesn't recognise a separate evidential burden. So that again, that's a legal error. It got the burden of proof wrong. So, and you can see how that will have tainted all of the evaluation of what follows.
There's always a practical, I mean, I understand the point. In practice, things somewhat dissolve into the scrap about the bits and bobs of evidence in front of the tribunal. The tribunal doesn't spend its time thinking, you haven't quite met your burden, therefore I'm going to hold on that point in favour of the other party. It just looks at the morass of evidence in front of it and it forms its own view. No, you're right. I mean, in one sense, well, maybe it's more a limb 2 argument about evidential burdens, but at this stage, yes, agreed. The evidence is largely in BT's hands because it's cost data. Yes, BT could have generated the data, but didn't. CAT is critical. Yes, the substitute, Dr. Jenkins' analysis, was found to be defective in material part.
Yes.
And the question then for the CAT is, I mean, boil down to, can I cope? Can I nonetheless, taking account of all these failures, infelicities, whatever, can I still come to a fair conclusion? And I think what's said on the other side is, notwithstanding all of this, it did.
But what we can't read into the judgment, because it's not there, is an acknowledgement that there was a failure to discharge an evidential burden by BT. Now, had the CAT understood that point and acknowledged it, we of course don't know what its judgment would have been, but I'd suggest that the CAT would have looked at its own findings on the problems with Dr. Jenkins' approach, and it would have said to itself, there's Supreme Court authority that places the evidential burden on BT. They have not come up with the goods, with the facts. And as a consequence of that omission, that failure by BT, which means that BT has failed to discharge its burden, on that basis, we therefore place weight on what we do have from BT before us, which is the RFS.
And just to be clear, you were returning to identify the legal errors, so that's the first
Yes,
one.
I'm grateful.
And we better capture the next two.
I'm grateful. So that was in fact two. So just so that's clear, the first one is missing the principle, overlooking
yes.
the principle. The second one is inverting the evidential burden of proof, or rather not distinguishing between the legal and the evidential, just placing a burden of proof on the CR, which in my submission is important because, to adopt your lordship's terminology, that's why one sees the CAT adopt this sort of morass approach rather than actually a forensic analysis of where the burden lay. And then thirdly, the third legal error was to fail to consider, properly or at all, the implications of BT's failure to discharge its evidential burden.
I mean, that last one doesn't sound like an error of law. That sounds like something evaluative.
I understand your lordship's point. If we turn up 666, which is where we were in the judgment, and the CAT observes, this is where they refer to the adverse inference, they reject it. And the premise upon which they reject it is that the simple point is that BT could have adduced relevant evidence. It did not, so such evidence is simply not there. Now, my submission on the error of law is that that is a failure of legal analysis, and it is one that denudes the Sainsbury's principle of any effect at all.
I mean, in that sense, is it not really a single complaint in legal terms, a failure to recognise the Sainsbury's principle?
Yes.
I mean, it's just another aspect of it.
Yes,
isn't it?
I'm just distinguishing, just taking it in steps, but it is one overall point. Your lordship has it. Now, I would just add, and on that final sentence, it is always true, it's universally the case, that where a party fails to discharge its evidential burden, then the evidence is not there. That's the whole point. If it was sufficient merely to make that observation, observe its absence, without asking why or what its absence might conceal, then the Sainsbury's principle is meaningless. It's otiose, it has no bite. And the evidential burden is without any significance.
I come back to the point about coping. I mean, I think what is going to be said against you is that forensically BT will agree with probably 70% of what you've just said, but then they say you misreflected what the CAT did as to the last 30%. The CAT was definitely critical. It recognised that there were failures on the part of BT. The Dr. Jenkins report wasn't as helpful as it should have been. But as it says in 666, they didn't think it necessary to draw an adverse inference. That's because, notwithstanding all those failures, they nonetheless got sufficient help from Dr. Jenkins' report that they could go to her baseline and adjust downwards, having rejected RFS, not entirely, but partially. And they came to a conclusion they felt was fair on the facts. So I really wonder where this all ends up. Just analysing what the CAT did and thought it was doing.
So again, I think I do need to show your lordship that the CAT's conclusion does not marry up with its findings. And its findings were clear that the RFS is a good method based on principles
Goodish.
adopted by... Well, actually, if we go to that, so that takes me back to where we were, and I apologise if this is a little jumping around.
This is sort of a rationality argument we're moving into when it's their evaluation.
And I certainly adopt that argument. That is an argument we advance, but we also say it flows from the legal errors that I've identified.
I understand.
Now, just on the coming back to Mr. Duckworth's approach. The CAT didn't only endorse the RFS and deprecate BT's attacks on the RFS. Oh, and I should, before I move to my next point, I should just show your lordship 676. Which we've already been to, where the CAT says, well, this is a FAC exercise, it's appropriate, halfway down. This is an example of where BT could have adduced evidence on the point had it wished to, but it did not. So what the CAT is saying there is that BT's objections to the RFS are simply hypothetical objections, and that's why they reject them wholesale, because they're not evidence-based. And of course, as I say, paradoxical, given it was BT's audited accounts. And perhaps just for your note, I'm not sure we did go to 704, which is another passage endorsing the RFS. But what I wanted to show your lordships is it's not simply the RFS, which is very hard to object to as BT's accounts, but the CAT also rejected in quite trenchant terms BT's criticisms of the uprating using the CPI index. Now, to give you one example, at 715 on page 219, that's the, it's, sorry, 299 of the bundle. Again, what BT, if I could just paraphrase, what BT was doing here was taking hypothetical pot shots at the CPI index. And what BT said is, so Mr. Duckworth's evidence was that the CPI index is itself conservative because BT had a programme of efficiencies in place, and that's at 711, they make that point. And BT said, well, that was a programme of efficiencies, but you know, efficiencies aren't always realised. And the CAT rejected that as another hypothetical attack at 715. We follow all of that, but there is no specific or detailed evidence from BT on areas where particular planned cost efficiencies had in fact failed. It could surely have been produced easily. So in truth, we see little reason to doubt, in general terms, some form of cost efficiencies were being made by BT over the relevant years, which affected SFE services. So far, the passages all point in the same direction, which is the RFS is a good resource for cost data. CPI uprating is conservative, in other words, it's generous to BT. It's a high measure of costs. And then we see at 718, just to follow through, the CAT deals with BT's objection that, well, it's just from 1 year. And the CAT rejects that halfway down. It says, however, we think that there are two countervailing factors here. First, it remains the case that 2009 is the closest available data set to the claim period. Second, if cost savings were indeed being made as from 2006, that suggests that 2009 is not an appropriate starting point. Is not an inappropriate starting point. So, and then the CAT refers to one of Mr. Beard's criticisms, and he argued that 2009 isn't necessarily arbitrary. We do not agree because, again, we think that there is sufficient in the materials to show that cost efficiencies were being made in the 2 years prior to 2009. So the CAT concludes, we accept the need for caution. We do not agree that it falls to be rejected entirely. As for the use of the CPI index per se, it does seem to us to be conservative and in any event not arbitrary. Now, I submitted to your lordships that there is a complete disjuncture between this reasoning and the CAT's subsequent conclusions. If we could just turn up 779B, and that's on page 313. This is where your lordship quotes the CAT's finding that they think that the RFS outcome should be tempered. At B, the CAT says the fact that the uprating by use of the CPI index may underestimate any cost increases. But that's not what the CAT found above. It just does not reflect its own findings. And it's a puzzle. I'd like to show your lordships another passage, which is also puzzling. On the previous page, that's 775. I obviously don't have time to go through every paragraph.
No, and we've got your very detailed, very helpful written submissions.
I'm grateful.
And we are time limited, so
I appreciate that. So the overriding point is when one does go through those passages, they all point in one direction.
so a disconnect between the conclusions in 777 and the actual reasoning, and it's a matter for us simply to compare and contrast.
A profound disconnect, and I just would draw your attention to 775, because that seems to be what the CAT bases its conclusions on as to common costs. And they say this: taken at face value, the existence and prevalence of deep discounts for bundles over the standalone equivalent does indicate the existence of supply-side synergies, which in turn are likely to come from common costs. If the cost of supplying a bundle of A plus B is less than the sum of the costs of supplying A and B separately, this provides a competitive explanation for the bundle discounts. It is the low marginal cost of providing the second or third product which makes it commercially attractive to offer such price structures. And your lordships can see there through to the end of that paragraph. Now, I say that's also curious because this is just speculation by the CAT. They don't refer to any evidence of common costs that explain the deep discounts from bundles. The analysis is also, with respect, completely defective. And yet this seems to be what it bases its conclusions on. Having rejected, as I say, rejected BT's criticisms of the RFS and the uprating, endorsed the approach, it then comes up with its own reason that it observes discounts. There's no analysis, there's no quantitative analysis here. But why I say it's defective, a bundle may be cheaper to supply than a landline on its own, because the incremental cost of supplying broadband to a customer taking a landline is quite low. And that's why a bundle, there are efficiencies across the two product offerings within the bundle, so the costs reduce. That is not evidence of the size of common costs incurred by BT Consumer. They've got that wrong. Bad reasoning. And it's important, it seems like a point of detail, but it's actually extremely important because that seems to be the basis for their conclusion that common costs may not be fully represented in the RFS because they didn't accept any of BT's objections to it. So it's a very strange passage.
Okay.
Yes, and I should, I'm grateful to Mr. Barry, I should also show you paragraph 753. And this is on the point about economies of scale. So Mr. Beard accepted that there was nothing more to the economies of scale point than the suggestion that if there was a fixed cost from one year to the next, which literally could not change, and it had to be distributed over fewer lines, there would be a high unit cost. But as an abstract point, we do not think this takes matters much further. Going to the end. Once again, if BT felt there were significant economies of scale that led to higher unit costs as voice lines declined, or the existence of important common costs between SFV and bundles, it was open to BT to provide evidence on either or both of these factors. It didn't do so. And that's why I say it's quite a puzzle then when one gets to 775, because the CAT seems to there be taking its own view. It's entirely impressionistic, not reference to any evidence, certainly no and certainly no quantitative evidence. And as they go on to observe over the page at 776, the parties did not, however, provide any detailed evidence on the existence or otherwise of such common cost synergies beyond the claims made by Dr. Jenkins regarding the scale of the indirect common costs. The scale of the indirect common costs, that's common costs for BT Consumer, and as you know, that's Dr. Jenkins' opinion. So this is a point that wasn't argued, for which there's no evidence, and yet it seems to be the basis of the CAT's findings, where the preponderance of the reasons say, well, the RFS is a very good method, CPI uprating is conservative. One really has to beg the question, why is it that the CAT then took no account of the RFS at all, and only estimated common costs based on the opinion evidence? Not even a cross-check. So at the very least, it should have inferred that the RFS was a reasonable proxy for total indirect costs, and it should have used that.
I think we're well into proposed ground 2, aren't we here?
So I haven't quite got there, and with an eye on the time, I wonder whether I could address your lordships on, well, if I could do 2 things on ground 1. First of all, just briefly turn up the operative part at 9:03, and then if I might address the case management question,
Yes.
and that will conclude round 1.
Yes.
So going to 9:03, I think you have these points. It's at 208 of the bundle. So I'm so sorry, it's 337 of the bundle, 208 the
Yes.
internal. So this is where, as your lordships know, the CAT performs the exercise, and as you observed, the 250 million is unsustainable because it takes no account of the RFS. So the CAT, having been really very complimentary, as one would expect, about BT's own accounts, it then doesn't use it. Now, what it certainly doesn't say in the passages we've now been through is there's a real problem with the RFS. On the contrary, so it is irrational, but it proceeds from the earlier errors of law that the CAT does not reference the RFS at all, even though it provides an indirect cost figure. And as BT accepts at paragraph 31 of their submissions, 250 is a massaged down version of the 264 figure.
It's a bit broad axish.
The massaging down is yes, just approximating, and it's a very minor adjustment. And
I'm just looking at the language, SIP 905. In our judgment, appropriate common cost starting point is 250 million. This recognises the problems with Dr. Jenkins' approach, which means that in our view, even her low scenario common cost figure is too high. Now, just standing back, that's a recognition of failure, because BT's failure led to Dr. Jenkins' report being inadequate. Those inadequacies and BT's failure were analysed, and that's taken into account. It recognises it, and they therefore adjust. Not as much as you would like, but they do adjust. So from the perspective of its approach, its judicial approach, I'm still struggling to see why they haven't taken into account what they perceive to be the evidential and strategic failures which you complain of.
because they failed to ask the question that they should have asked, which is why did BT not produce any factual
But
evidence?
Doesn't this take that account?
Well, it's hard to see how a
Recognises the problems with Dr. Jenkins' approach, which are twofold: BT's failure, and in consequence, Dr. Jenkins' inadequate analysis. Why is that not taking it into account?
because it's not recognising that her method was unreliable, which is what the cat says.
It has. It said even the bottom line of 250 is not good enough. I mean, your quibble is really the extent to which there's a discount from the bottom line. And the problem is that's a matter of evaluation and evidence.
Well, I come back to the point that it takes no account at all of the RFS.
That's a rationality point, I think.
Well, I'm not sure that's right, because again, it's the jumping off point, the point of departure is the heavy evidential burden on BT. And the reason for that principle is you should use that firm's cost data. And that's what the class representative did once BT said, we can't give you anything contemporaneous. Moving on then, if I may, to the case management point.
Just to be clear, the point that we've raised and BT have elaborated upon is that if we're going to criticise an approach, you've really got to be able to say the cat erred at an early stage in failing to require BT produce the data, because otherwise it just relied on the default evidence, namely Dr. Jenkins' report, which was then subject to iterative analysis through expert meetings, through the hot tub, and then it's analysed by the cat. It's a bit difficult, or it's more difficult, I don't suppose it's impossible, to say that there's a cat failure if no one asked it at the outset to order BT to generate the data. That's the point.
I understand that, and I'm grateful for that, and I will respond to that. But before I do, what we say is, because, however it came about, the only thing that the cat could do at that point, having had this failure, which we say came about because of the way BT managed the issue, the only approach, the only sensible, coherent approach was to draw the adverse inference, not to shrug its shoulders and say, BT should have produced this evidence, but we don't have it, so we'll use some evidence that we think is not reliable, and we'll approximate a little downwards. Now, BT...
And I see that if a failure becomes evident, or more evident after the event, it doesn't prevent a court from saying,
yes,
with the benefit of hindsight, something more should have happened.
yes, yes. Now, yes, BT lays the blame at the class representative's door. It's paragraph 7 of Mr. Beard's submissions. BT says, well, the class representative didn't suggest that BT create new ex post evidence. The short answer is that the reason the class representative did not suggest this was because when he asked BT for SFV cost data after certification, BT insisted that the information was impossible to produce. Now, if I might just show your lordships the first time that was put in writing by BT, that's Core Bundle Volume 4, Tab 26, page 1296. Your lordships have that. The first page there is an email from BT's lawyers, and it attaches a schedule responding to the class rep's disclosure requests. And then if we go down to page 1305, now I'm working off an electronic copy. I hope
Don't worry.
I hope the hard copy is legible. I know it can be a little small. So page 1305, tab 27, bottom row. You see there on the in the left-hand column a request for a full description of the activities and costs included in each cost category and the methodology for allocating attributing costs and so on. Down to the level of SFV services, BT said this. BT does not record the retail costs per line or differentiate between access and calls. BT records the total retail costs across BT Consumer as a whole. For the years from 2015 onwards, BT expects to be able to provide an estimate of annual retail costs for all voice services. And then the key sentence, BT does not currently consider that it will be possible to break this down by customer type, i.e. SFV as compared to other voice customers, or to differentiate between access and calls. And Mr. Bid quotes this passage in his written submissions, but he omits that sentence. Now, I don't think we need to go there, but the class representative wrote again in April that year, setting out his understanding that BT was, quote, unable to provide profitability data for SFV services. And he asked instead for information which will allow an attribution of costs to SFV. We then move
So you've got
forward.
the reference to that.
Oh, I'm so sorry. That's Core Bundle, Volume 4, page 1321. So that was his request in the light of BT's response. Then if we could, it may be worth just turning up the expert's joint note. This was a joint note on
I'm sorry, I'm just making it, I'm just catching up.
I'm so sorry.
Just making, I've got that correct reference. Say
Yes.
1321.
1321, 1321. Volume 4.
See, paragraph 7. Yeah, thank you.
Now this is one that may be a little challenging in hard copy, and I can read it out if so. The experts produced, as you'll have seen, a joint note on proposed methodology in relation to disclosure. That was signed by them in July 2022, so the same year as the BT response. And it annexed a gaps table. And the gaps table refers to the March schedule from BT, and it records the experts' joint understanding that it will not be possible to break margin and cost data down by customer type. And that's at page, it's volume 5, tab 53, page 1866, and it's the top right-hand cell. The last sentence.
Sorry, it was tab 50.
Tab 53, I'm so sorry. Volume 5.
And the page was?
Page 1866. It begins, just so you have it, at page 1862.
Yeah.
So that's where they say, look, we understand that BT doesn't think it can provide the disaggregated data on SFV customers.
And I've got a horrible looking schedule with very, very small writing. Where is
Yes,
it on the page?
so on the page, it's top right hand corner. It begins, shall I read it out? It begins in relation to Frontier's existing request. Can your lordship see that?
Yeah.
I personally couldn't see the hard copy. In relation to Frontier's existing request
I've got
for
it,
BT,
yeah.
that's the one. And then
I
it's
found
the
it.
final,
Yeah.
the final sentence. BT does not currently consider it will be possible to break this down. So not possible, they say. Now,
And the next sentence doesn't matter. Or next sentences don't matter.
yes, just not for these. And that's a reference back, as I say, to the March schedule. Now, the point seems to be common ground. Paragraph 8C of Mr. Beard's submission stress that, this is volume 1, tab 2, page 24. Mr. Beard emphasises that BT reiterated on multiple occasions, including a letter in November that year, BT's inability to disaggregate costs or revenues for the whole voice division. Now, it was entirely reasonable for the class representative to take those multiple reiterations by BT at face value and to treat BT's assertion of impossibility and inability as true. Now, regrettably, we now know that BT wasn't being candid because the CAT has determined this point. And the CAT held at 703, which is page 297 of the bundle, this was by no means an impossible exercise. That's 703. And you see there that that was based on two pieces of evidence. BT's section 135 response to Ofcom, where they informed Ofcom that it could do the allocation at modest cost. The CAT said that's modest, £260,000 in the scheme of the amounts at stake and the amounts spent on evidence. And also, the CAT refers to evidence that emerged from Mr. Cackett, the finance director, for the first time in re-examination, that BT Consumer did in fact perform some informal allocations to the product level. Those were his words, the product level, in other words, SFV. That's in my submissions at paragraph 19, volume 1, tab 1, page 12. I should say it's troubling that BT now suggests that the class representative should have somehow read the runes buried in a footnote to Mr. Cackett's witness statement. We can go there if helpful, but I can just give your lordships the point. Buried in a footnote, he explains unit economics as the financial impact of an individual product sale. But my lords, Mr. Cackett's witness statement was absolutely clear on its face. He said BT made some estimates of how indirect costs are spread across the different divisions of BT Consumer. A division would be voice or broadband. He did not refer to any allocations to SFV services, which is what the class representative had been asking BT for. So when one looks at that evidence, as I say, it came out for the first time in re-examination that they did perform product level allocations. So BT's claim, before your lordships today, that the class representative should have told BT to do the work is really to pass through the looking glass. The issue is BT's lack of candour at a time when it should have been engaging constructively with the class representative on disclosure. It should have explained at that time in 2022 that back in 2017 it had told Ofcom that the work could be done and what it would cost, and that there are in fact some rough and ready allocations that exist. So information not shared by BT, although relevant. Now, I just want to show your lordships this. In a final twist, almost 2 years later, BT wrote a letter to the CAT during the trial after the Cackett bombshell. And that letter is in volume 4, tab 41, page 1363. And it's the final paragraph on the page. So that you'll have seen in our submissions, the CAT expressed some surprise and some concern about Mr. Cackett's evidence on product allocation, and that prompted BT to write this letter. And I would ask your lordships to read the final paragraph, but the sentence I want to draw out is the final one.
Sorry, what, this is page
1363.
So the paragraph beginning to the extent available.
Yeah.
That's it. Mr. Armitage reminds me it's actually the penultimate and ultimate sentences.
Yeah.
BT did not, however, at any time suggest that because BT does not allocate costs in this way, therefore it was not possible. As set out above, it is, and has been throughout BT's case, that such cost allocations properly undertaken with the available data are possible and demonstrate that BT SFV services were not excessively priced. Well, if they demonstrate that, one asks, why didn't they produce it? But I've shown you that they said it was impossible. And, my lords, it's precisely because BT said that the task was impossible that the class reps experts turned to the next best option, the RFS. Now, I've just got two more short points on why BT's attempt to shift the blame to the class representative turns matters on their head. BT's expert apparently did not think that her analysis of indirect costs would benefit from factual information from BT about cost categories for voice services. And this is a point that BT pressed. Just for your note, it's addressed in paragraph 11 of our written submission. If we could go back to page 1866, which is the gaps table, one sees something quite surprising here.
This is core 5.
This is core 5, tab 53. And
Yeah.
I hope it's sufficiently legible. But what you see in column G,
And we're still on 1866.
1866, and column G is, as I have the benefit of expansion.
Yeah.
Can your lordship see that's about 4 in? The last one is I.
Yeah.
And the class representative. So column G was class rep only requests. And so Frontier, the class representative experts, asked for a breakdown of individual components, cost categories of SG&A and DNA annually over the relevant period at the BT consumer level, broken down into the services of voice, broadband, and so on. Now, that request was prompted by the fact that BT said they couldn't do the impossible exercise. So Frontier said, okay, well, we're going to have to do something about this. Could we have this information, which would inform an allocation exercise? Now, given that what Dr. Jenkins was doing was using her subjective judgment, in the cat's words, to estimate the size of common costs, you'd think that information would have been extremely helpful to her. But not only did she not ask for it, so as I say, it only appears in the class representative column, not the joint request column. The joint request column is to the left. But I'd like to show you a letter from BT core bundle 4, tab 30, page 1322. Yes, that's right. Yes, sorry, it's inflated on my. Now this is a letter.
Sorry, which page?
I'm so sorry. 1322.
Yes.
So that's the first page of the letter.
Yes.
And if we go over the page, this is where BT responds to that column G request that I just showed you. And they say this: Frontier has made a number of requests in row 28 of the data table, which Auxera, BT's experts, has not made. Please explain why the CR considers it's proportionate for BT to locate and provide this data to the CR in circumstances in which BT's economic experts' view is that the data is not necessary to address the issues in dispute. And they say there, we're currently investigating, and they go on to reject that request. Just for your note, that's at Core Bundle 4, tab 34, page 1338. So that takes me back to my submissions on the adverse inference. A decision was made by Dr. Jenkins not to ask for information that would have assisted her exercise. And that really is a puzzle. Finally, on this point, you have our submission, I think, in the written submissions, that BT also kept the CAT and the class representative in the dark about its methodology on common costs until Dr. Jenkins' first report was filed. The timetable was such that we got that at the end of September for a January trial, so it wasn't very long before trial. Now, your lordships will have seen that we complained at the July CMC bitterly about the absence of a level playing field. Now, at that stage, the class representative made amendments to the claim form to reflect its use of the RFS. And the CAT directed that the class representative not just put in those amendments, but put in a really detailed annex, which set out, it was essentially an economist annex. It set out the full methodology in real detail. And the class representative was very happy to do that. But his complaint to the CAT in July was that it wasn't a level playing field because we knew nothing in the July before the January trial about BT's methodology. Their pleading was absolute bare minimum. I think we needn't go there, but just for your note, volume 2, tab 18, page 650, lines 4 to 9, the chairman
650.
I'm sorry, 650, 650, lines 4 to 9. The chair agreed, he seemed to agree that a proper pleading was required from BT, but he refrained from making that order. The order only directed the class representative. And then what happened is that BT amended their defence, having been made very clear that a proper defence was expected, setting out its methodology, but its amendments were bare minimum. It set out nothing about, for instance, Dr. Jenkins' subjective judgment. So it was only in September before trial that the methodology became clear. Now, if we go to Core Bundle 2, tab 18, page 635.
How are you doing on time?
Well, I think what I'd suggest, I'm obviously in your lordship's hands, is that after this I make a brief point on ground 2. It's really a very brief point. And ground 3 is really addressed in full in our written submissions. Of course, if your lordships have questions, or I can come back to it and reply. But I think...
And I mean, I follow the way you're proposing to go. We obviously need to keep to
Yes,
the
I have 10
11:55
minutes.
deadline. Yes.
Yes, 11 perhaps, yes.
Yes.
Yes. So page 635 of tab 18 for bundle 2. Mr. Beard, this is the July CNC transcript, and Mr. Beard said this on the amendments and the annex setting out the economic methodology. Her answer was, don't worry about it, I've shown you the claim form, I've shown you the old reports, you don't need to think about these things, and actually it's terribly unfair that BT haven't set out their benchmarks so far. I should say I don't accept the characterisation of my arguments here, but that's not to the point. But he criticises me for saying it's unfair we don't have BT's benchmarks. He says that's not the right approach in relation to class certification. It's not the right approach in relation to the gatekeeper role after certification either. So BT was saying the proactive gatekeeper role that your lordship adumbrated in the McLaren judgment only applies to the class representatives methodology. It doesn't make demands of us. And that was the problem. It was far too late when we understood that BT rejects its own audited accounts and it relies on opinion evidence untethered to facts to make out common costs. So with my last 10 minutes, I don't have time to make a submission about a phobia. I can come back to that in reply, but essentially our point is Sainsbury's, the heavy evidential burden isn't governed by a phobia. So last couple of points. Your lordship queried whether this is just a broad axe exercise and that it has nothing in common. And my submission is that actually what the CAT did in relation to the allocation exercise has nothing in common with that judicial tool, which is well honed, for dealing with imprecision in economic data. That's not what the CAT was doing. The defect wasn't approximation. The defect was to determine the proportion of BT common costs to be allocated to SFV services on the basis of Dr. Jenkins' figure of 50% adjusted downwards to 40%. And BT, Mr. Beard accepts in his submission that it is that downward adjustment, 50% is the anchor. Now the CAT's rejection, so that 50% comes from the SAT-COMBI exercise. I'd like to show you just one reference in the judgment, which is paragraph 856. And that's volume 1, tab 9, 300, page 328. They said this: overall, we consider that Dr. Jenkins' approach, insofar as it's based on the SAT-COMBI exercise, is seriously deficient, and it cannot justify the competitive benchmarks which are said to result from it. So that's 856. For your note, 884 is to similar effect. There's also, for completeness, 854 to 855, 870, 874, 885, 889, 894 and 896. And so I come back to my metaphor, if I may, that if the well is poisoned, you don't avoid sickness by taking a little less water. They adjusted the 50% down to 40% based on a seriously deficient approach. Lastly, the second problem is the CAT's sense check, or they describe it as a sense check at 910 of the judgment. That's page 14 of volume 1, tab 1. I think I may have misspoken. I'm sorry, I had a wrong reference. The judgment's, of course, volume 1, tab 9.
We have a tab
But
extracted.
you have it. You have it. Now, it's a point I've made, but it's relevant to ground 2. It's hard to understand why the CAT did something really very convoluted at paragraph 910, which is some strange hybrid of Mr. Duckworth and Dr. Jenkins. I'm not going to spend time trying to unpick it because it's something of a head scratcher. But it's hard to understand why the CAT didn't do a straightforward sense check of comparing its figures for SFV allocated indirect costs, which was based on Dr. Jenkins' evidence, the adjustment to the 264, and then the 40% of that. Why they didn't check that against Mr. Duckworth's figures based on the uprated RFS, which appear in the judgment. And I showed you table 557. That would have been a very sensible sense check to do. And it would have shown that the CAT's assessment was very high in relation to the BT audited accounts figures. Those are my submissions. I note I've got 5 minutes, but I think I will leave ground 3 rather than
That's very helpful. That's very helpful. Thank you very much, Mr. Beard.
Mr. Beard, could you? Thank you.
Thank you. So I'll focus on ground 1 and deal with law, approach to judgment and case management in addition. But just to highlight some of the key points that I'm going to be coming back to. The fundamental issue here was the CAT exercised judgment in relation to how it calculated the LIN 1 benchmark. What it was doing was looking at material that it had before it, both factual material and data that had been disclosed, very extensive data. I mean, occasionally Ms. Kreisberger lapsed into suggesting that BT hadn't been providing data. It provided vast amounts of data. What Ms. Kreisberger's central complaint is essentially that data wasn't as granular as in fact the class representative would have liked. But that's because BT didn't hold that granular data. It didn't hold it at that level. And so when we come back to the case management observation, when we say it wasn't possible to provide the breakdown, what we were saying was it wasn't possible in the spreadsheets and the data that we were disclosing to actually break it down in the way that was sought. And that's just a fact of the material that was there. What the CAT then talks about is a potential further exercise being undertaken. And as I'll come back to, we say that's not what Sainsbury's was really about. But the essence of this is that there isn't a point of law here. As my Lord Justice Green's already indicated in the course of exchanges with Ms. Kreisberger, what we're really asking ourselves here is whether or not the CAT was taking leave of its senses effectively in deciding that it didn't accept either set of expert analysis based on that data having regard to the factual material, when in particular it assessed common costs. Because common costs were a key component of how you built the competitive pricing benchmark under Lim 1. There wasn't actually any dispute about that. And although Ms. Kreisberger has talked about how complimentary the CAT was about the RFS, and we criticised the RFS, and all of our criticisms were not accepted, and that's not at issue today. But fundamentally, as the class representative's expert himself accepted, that data from 2009, so 6 years before the start of the claim, it didn't identify common costs at all. So what ended up being done was a suggestion by both experts that actually the common costs in this case were very low. And the tribunal just rejected that. And it rejected it for a whole range of reasons, taking into account a whole range of material, including Dr. Jenkins' report. But in doing so, in rejecting those submissions, it was carrying out the assessment. And in many ways, the easiest way of dealing with this is actually to go to the overall conclusions on the competitive benchmark, which we can pick up in the bundle, and I think it is at 336. And although Ms. Kreisberger has danced through with elegance, touching on particular paragraphs, the whole of the background here is very extensive, and you have to read it all together, but the conclusions say, it'll be seen from the above that we don't reject either expert's methodology entirely. So the tribunal was very clearly having in mind the RFS-based methodology that the class representative put forward, and thus we don't accept in either case that no reliance can be placed on the other's expert methodology at all, although each party invited us to do that. Instead, and perhaps unsurprisingly, we considered that because each side's methodology contained a number of problems, it's necessary to strike a balance in terms of the outcome that reflects the weight which we consider should be given to each methodology. And then it focuses in particular on this common costs issue. The starting point for common costs being the total proportion of BT's indirect costs, which are common. I mean, I can go back through the definitions, but I'm sure that's a joy you don't need.
It certainly is a joy we don't need.
The proportion of such common costs which should be borne by SFE services, so the subcategory of services within BT Consumer to which the common cost should be attributed, and then the application of the margin that had been ascertained. And then the exercise will result in a specific competitive benchmark, which can then be compared to, and the ARPU is the average revenue per user. So it's the price, effectively, per user, but it's for both the lease of the line and the calls. And the percentage excess over the competitive benchmark can also be shown. On the basis of those figures, an assessment will be made as to whether there's an excess above the pricing. So this is all the Lim 1 exercise. But in a way, those 2-3 paragraphs capture the conclusion here that what the CAT was doing was carrying out an assessment. And what it was doing was taking into account all of the data that had been provided through a very, very extensive disclosure and case management process that had been expert-led. Because although Ms. Kreisberger talked about how expert methodologies only came out later, and I'll come back to the transcripts, actually this was a case where the CAT exercised hands-on case management all the way through. It required joint expert notes to be put forward. It required early meetings in relation to these issues, and as the description goes, it was an expert-led disclosure exercise. And that's why you saw in those various passages in the documents, the gaps table and so on, how you had the different accounts. And it was BT going back and saying, we do not have the data that goes beyond BT Consumer, that breaks it down into subsets of customers, and in particular, we don't have the sorts of profitability data broken down in those ways. What the CAT is saying is that it's concerned that it would have been easy for BT effectively to have generated that material. But that's a very, very different exercise. That's not a disclosure exercise. And so that's why we say that overall here, the CAT, in the words that my Lord Justice Green was using, coped, notwithstanding the fact that it didn't accept either set of experts' opinions comprehensively. And that doesn't disclose any error of law at all here. That is paradigmatically what you will get where you get a conflict of evidence, and in particular conflict of methodology between two sets of experts. The tribunal has to deal with these issues. So in those circumstances, we say there is nothing to see here inherently, either on the substance or on the case management arguments. In fact, this is a case where you cannot level a criticism at the CAT saying it should have grasped the nettle earlier. You cannot level a criticism at BT that it didn't explain itself earlier. You can't level a criticism at BT's experts for not setting out what they were doing earlier, because there was this process of case management that was being looked at actively by a tribunal that didn't just include a High Court judge as its chairman, but obviously included an expert economist. And of course, in this lengthy judgment, one can infer that the contribution of that expert economist was potentially quite extensive, given the nature of the analysis. And that, of course, suggests no criticism at all of other members of the panel, but the levels of detail there suggest that there was an expert economist engaged in these exercises. So that's why we say that in essence on ground one, it starts from a wrong position on law in relation to Sainsbury's. It is profoundly wrong in relation to its interpretation of the judgment, and is grossly unfair to what the CAT has done. Even if we as BT might disagree with parts of it, that does not mean that there is any error of law being made as suggested by the class representative. And it's also, as I say, wrong in its reappraisal of the case management process. Now, it might just be worth, your Lordship, I think, both of your Lordships have very closely in mind the Sainsbury's admonition, paragraph 216, in that judgment about the situation where a defendant is raising a defence of passing on, and it said, well, look, we raise a defence that if there is any overcharge, you actually pass it on, and you, O claimant, actually have the real detail in relation to this. And in those circumstances, it's obvious that extensive disclosure on the part of the claimant is going to be required, and that's what the heavy evidential burden is focused upon. Now, we accept that doctrine.
Sorry, when you said focused on what?
I'm sorry, it's focused on a situation where essentially you've got a claimant saying, I've suffered an overcharge. The defendant says, well, you didn't suffer an overcharge, but if you did, it didn't stick with you, it was passed on elsewhere. We raise that argument, but obviously we don't have the information about how you did pricing, what you might have done. And in those circumstances, you, O claimant, have a heavy evidential burden in those circumstances.
Yeah.
And so that's the context of the Sainsbury's observation at paragraph 216. And although this is now the centrepiece of the class representative's case, actually paragraph 216 of Sainsbury's was only referred to in passing once in the class representative's own closing. I'll just give you the reference. It's at page 2614, and it's in footnote 1694.
Which volume are we in?
Ah, now there.
But it was referred to. I mean, in a sense,
Yeah, it was
It's-
referred to. I'm not going to.
it's not a magical principle.
No, it's not a magical principle. In fact, the point I was going to make is it's not a magical principle. It isn't
It goes
doing.
back to Lord Mansfield in 1774, according to my
There
research.
is nothing new in the law manual. Yeah. I'm not trying to turn Sainsbury's into a magical principle. I'm actually saying it's not a magical principle. What it was observing there is that in those circumstances, because you as the claimant had all this material, you should disclose it. But there is nothing in Sainsbury's which is saying, oh, and as a claimant, you had to create or do analysis or put forward other material. That's not what's being talked about there. And as your lordship,
I'm not certain about that. I mean, the sense is, who has it within their power to either produce, generate, provide the data, information, evidence, material, etc., which is relevant? And here the cat was quite clear, BT did have it within its power, within reasonable cost and time to generate the data. So you could have done, you chose not to. That was the cat's finding.
yeah, it was, but I think it is also worth bearing in mind here what the cat's saying, because what it's talking about is generating some kind of data, but of course in circumstances where what you'd be arguing about is how you do this allocation, you're talking about, you know, how does BT go about actually providing material that does this supposed allocation?
Of the staggeringly vast amount of data provided, this is more important than a great deal of other data.
Well,
In terms of the Lim1 cost analysis, this is fairly big stuff.
Yeah, I'm not going to dispute that it's fairly big stuff, but it's also big stuff because it involves an awful lot of discretion in relation to these issues, because there's a slight danger with going back and focusing on the RFS. The RFS, of course, was what's referred to as a fully allocated cost model. So you took all the costs that BT incurred and you stuck them on various products for the purpose of regulatory monitoring. And one of the big points you have, and it's one of the reasons that the RFS is actually criticised in the course of the CAT judgment, is that that imposes a rigidity on where the CAT costs are being attributed to particular services, and therefore how they can be recovered through pricing. And what the CAT observes, and I don't think this is contested, is that you need as a business to have a multi-product business to have flexibility about how you can recover costs. It can't be infinite, so you can't load all of your costs onto one product and then justify some super high price in relation to it. But that flexibility is not recognised in any sort of fully allocated costs mechanism. And that, as your lordship already identified, was one of the underlying criticisms of RFS generally, not just in relation to its failure to capture common costs. It's actually too rigid for a realistic approach to how you set a competitive benchmark. And so you're right that this is big stuff, but that what we're talking about in relation to these issues is all of that data being provided that we had, all of the, and that's referred to as what's referred to as structured data in the documents, because that's the stuff that's coming out of spreadsheets and being provided. And then you also have vast amounts of documentary material being provided, which also indicates what BT might be doing from time to time. And I'll come back to it. I mean, Mr. President talked about the Cackett bombshell. Mr. Cackett was clear in his witness statement that BT occasionally did do some sort of cost allocation exercises as part of its ordinary business processes, and we provided the documents in the course of disclosure in relation to that, but they were very limited. They weren't covering what Ms. Kreisberger is referring to here. But in any event, the point I'm making in relation to Sainsbury's is it isn't a magic principle. It is focused on the situation where you have this asymmetry. Trucks doesn't take matters further forward. Trucks is in fact a very different situation. In Trucks, you'll recall the criticisms were twofold. The first was that actually DAF hadn't put forward evidence as to how the cartel worked, which would have informed these matters, because it hadn't provided witness evidence in relation to these issues. Now, here, there's no parallel criticism because BT put forward as witnesses a series of individuals who were closely involved in all the pricing decisions. And therefore, there was full scope for cross-examination in relation to all of these issues. And of course, you're dealing with a different situation anyway, because of course in Trucks, you're dealing with a follow-on case. Here, you're dealing with an initial finding of liability case. and what was being described was how BT did it. Again, I'm not going to go through all the sections in the judgment, but there's an extremely extensive consideration of all that witness evidence, particularly in relation to the Lim 2 issues, for example. Again, and I won't trouble the court in providing any detailed submissions on ground 3, given Ms. Kreisberger's position on it, but that material really explained how BT was going about things. So you have the full disclosure exercise that's been provided, you have witness statement evidence being provided, and there's no suggestion, as there was in Trucks, that somehow there was a problem in relation to the way in which the experts had engaged in these circumstances. That's not what the tribunal is identifying as a concern at any point. So Trucks is very different. So yes, the principle in Sainsbury's isn't magic. It can be flexed for different circumstances, but it can't shift the burden of proof in relation to these matters. And in circumstances where we come forward with witnesses, we'd engage in an inordinately large and lengthy and involved and carefully case-managed disclosure process. And we had been through iterations of amendments that were all managed by the CAT. And it had set down the timetable, and the CAT, actively case managing these matters, had followed this process through. There is no proper parallel, effectively, with the position in relation to Trucks. And as again, I say, it's not a magic principle in any event. So in those circumstances, the question then arises, which is, well, if BT could have carried out this further analysis, should the CAT have done something different about it? The focus of the challenge was you should have engaged in drawing adverse inferences. That seems to be somehow less emphasised in Ms. Kreisberger's submissions today. And I won't take you to it unless it assists. We have copies of it, the Phones for You judgment that came out, which obviously deals with questions of circumstances of inferences, and in particular talking about the discretion that a court must have in when and whether to draw inferences, and the idea that the Court of Appeal should be potentially identifying an error of law in the refusal to draw inferences is one that one should be extraordinarily slow to conclude arises, even on some kind of arguable basis, and there is no basis here. The tribunal clearly had these issues very squarely in mind. All the paragraphs in the judgment that Ms. Kreisberger is going to, saying the CAT was critical of BT's evidence, that is showing that the CAT had this very clearly in mind when it made the decision not to draw adverse inferences in the circumstances. And so, ironically, all of these citations don't support Ms. Kreisberger. They actually support the fact that the CAT was very much cognizant of these issues. And as I say, there is no arguable basis that the CAT got it wrong in deciding inferences shouldn't have been drawn. And then we're in the territory of asking ourselves, could the CAT cope in these circumstances? And as I say, when we're looking at it in those terms, what we see in the judgment, even if we just turn to the index for the judgment, which is actually quite helpful as a way of, as indexes do, piloting you around the document. But just if we go to it, so I think it probably starts at page 131 in the bundle, but you may have it loose. You see how it's very systematically worked through. The core issues are described. The evidence that's before it is set out. The general legal position in relation to United Brands, which obviously has been chewed over in a number of cases, in particular before this court, and it has been dealt with. And then we've got a range of factual considerations that are run through before we get to market definition and dominance. Then we have the Lim 1 methodology's description, where, again, I'm not going to take you to it, but you have this consideration of the two sides' positions on these issues. It then diverts into reasonable margin, which is a slightly separate topic. But then we come back to an inordinately long section, analysis of the RFS methodology, 161 through to 184, the internal page numbering. And it deals with the various objections that BT made that said this is irrelevant. And the tribunal rejects that contention and says it is relevant, but And that's the conclusion. And that conclusion was open to it. And then it goes on and looks at Dr. Jenkins' methodology. And again, it doesn't accept Dr. Jenkins' methodology. It recognises that Dr. Jenkins' methodologies do have the benefit of identifying common costs. But then it says she's overcounted them. And actually, then we have to use our judgment in relation to it. And then we get to the overall conclusions on competitive benchmark that I was taking you to. You can pick out all sorts of paragraphs going through there. There is no error of law being identified. It was a consideration of two competing accounts, neither of which is entirely rejected. Ms. Kreisberger is wrong in relation to ground 2 and some of the drift of ground 1 to say it was irrational for the tribunal to take into account some of the data and analysis that Dr. Jenkins carried out in order to come up with a common cost figure, particularly in circumstances where the RFS material relied on by Mr. Duckworth didn't do that at all. And so could it cope? The tribunal reached the conclusion it could cope in those circumstances. And in those circumstances where it can cope, and where what it has done is patently not irrational, there is no error of law to be identified in relation to this matter. There were various points thrown out along the way that are suggesting that the tribunal missed bits and pieces. It didn't carry out cross-checks and so on. I'm not going to go through all of that because there are inordinate numbers of cross-checks and discussions about things. Ms. Kreisberger might say now, oh, well, this was the one that should have been done. She said, well, a comparison, for instance, against indirect cost totals. Well, actually, they do refer to and consider indirect cost totals, for example, but it's along the way in paragraph 909. It baked into what they're doing here. But to say they're missing these things is just not right. It's all part of the overall evaluation. And I can take you through the detailed sections where the account in relation to the RFS is less than complementary, as it were. But I think your Lordship already has the point that there were criticisms of the RFS methodology because it was drawing on matters long before, and because it was this sort of fully allocated cost model. And also that when you had decided as the tribunal you wanted to construct the competitive benchmark having reference to common cost, it just didn't do those things for you. So unless you want me to go through those paragraphs, I won't distract you with
That's
them.
a matter for you.
Well, I will briefly then just highlight a couple of points. I think we've been there, but paragraph 777, which is conclusory in relation to these matters. This is at the end of the section on the RFS methodology. And I think this is important. So it's at page 333. 313, I apologise. So this is after, as I say, a section that started way back dealing with the RFS. Back at internal page 161, so 290. But the important thing to just bear in mind here is not only the criticisms that my Lord Justice Green has identified about concerns in relation to uprating, lack of flexibility and so on, but because there was this concern about focus on common costs, one of the key problems with the RFS identified in 777, we do not feel that the evidence adduced by the class representative clearly establishes that the common costs of BT Consumer are so insignificant or immaterial that any discussion of them becomes irrelevant. To that extent, we reject the class representative's reliance on such a proposition. Nonetheless, we do attach some weight to the notion that it would be surprising if the common costs were as high as Dr. Jenkins has suggested. So again, it's recognising that you have these other models and arguments out there, But it's saying, look, when you construct this benchmark, you create a cost stack involving the common costs. We don't accept the class representative's arguments and the submissions of its experts in relation to these matters. And that's when you get onto the conclusions on the RFS methodologies. We don't accept BT's contention that it's not fit for purpose, but, and your Lordship has these paragraphs in mind, one data point ending in 2009, CPI underestimating costs increases, the fact that there's no flexibility. Precisely how these concerns are taken into account in our ultimate findings will be considered after we've undertaken our analysis of Dr. Jenkins' material. So each of those parts of the conclusion are based on the prior text here. And the points on flexibility, for example, are dealt with at 675 and 676. There are points on each of these issues in 779 and indeed the prior material in 777 throughout that section. And then, as I say, we go through Dr. Jenkins' methodology. Where there are a range of criticisms of different methodologies, SAC combi, DSAC, cross-checks using different methodologies for fully allocated costs, methodology and so on. But they're all being considered. So we've had cases previously where the CMA or the CAT has been criticised for focusing only on one particular pricing methodology. That's precisely not what this tribunal was doing. It was taking into account both the range of evidence provided by both sides and all these different methodologies and synthesising in its own judgment how you came out with a sensible figure. So, as I say, to say it's complementary of the RFS is wrong. To say that there is only an error of law here is wrong. In those circumstances, ground one, we say there is nothing to see there, and it is an unfair appraisal of the tribunal's judgment to suggest that actually it did anything irrational and that somehow it was not open to it to reach the conclusion that it could cope, to use the informal language rather than legal circumstances. And I've dealt with the inferences point.
If either party, if there's any paragraphs in the recent Phones judgment you want us to just consider, you don't need to deal with them now, but if there's any just paragraph numbers you think we ought to be
I'm certainly
paying attention to, would you let us know?
Yeah, so I think probably 307 and 309 probably are the most important. And of course, it's worth bearing in mind what the context of the argument there was. Yeah. That was to do with willful destruction, effectively. So it's a very, very different circumstance, a very extreme circumstance. And I should just put down a passing marker. These arguments that have been asserted that BT was acting strategically or fabricating material, they're just utterly unfounded. It is not what was going on here at all. It's quite unfair. They don't take Ms. Kreisberger's arguments further forward. They are unjustified. There smears on BT in circumstances where BT provided vast amounts of material.
I think we just simply start with the CAT's own findings about the process. I mean, there's neither more nor less to say about it than what the CAT said.
Now, we may have views about the CAT's comments, but for the purposes of today, we hold our tongue in relation to those sorts of issues. We accept that that's the position in relation to it. But the CAT doesn't say this was strategic, it wasn't fabrication. Those aren't language, that isn't language that the CAT used. And just one other point, one other reference I have scribbled down just in relation to the overall conclusions. I took you to 897, 898, but it is just worth emphasising that in analysing the common cost starting point for the start of the claim, and 904, that's where the tribunal specifically says, well, actually, the RFS doesn't assist us in this regard. So with that, on ground one, I was going to move on to some of the case management allegations. I've already traversed, I think, the central proposition, which is this vexation on the language of not possible was to do with the disclosure exercise. It was not possible to get from the data we had the breakdown that was being requested. That didn't exist. And that has been clear throughout. And the suggestion that somehow the cat erred by not grasping the nettle in relation to these issues is just without foundation in the context of this very involved case management process. And in the course of our oral submissions, Ms. Kreisberger didn't develop the theme that somehow BT should have made clearer sooner that it didn't systematically attribute indirect costs to the standalone fixed voice services or subcategories. That is, with respect to hopeless proposition, that has been clear since back in 2017 during the course of the Ofcom investigation. Ofcom stated as much in its provisional conclusions, and we've dealt with that in our submissions at paragraph 8A. When disclosure was first discussed between the parties almost 2 years before the start of trial, BT made it clear it did not systematically attribute indirect costs across its SFV services separately from indirect costs of BT consumer division as a whole. So it didn't allocate costs to this subset. That's why it wasn't possible to give data, because we didn't have it. And what the letter that Ms. Kreisberger referred to later on in the process, saying we've never said you can't attribute costs, is just a truth in relation to these issues. There can be an exercise in attribution. We weren't denying that there had been one back in the day in relation to the regulatory financial statements on a fully allocated cost basis. We weren't arguing that the tribunal couldn't reach a conclusion on these issues. But what we were saying was, we didn't do that. We didn't do that, and we didn't have that data. So it was not possible when you're discussing disclosure to say, yes, we can provide that, because we couldn't.
Can I just talk around a moment how
please.
this works? So you say, well, as a matter of disclosure, we don't have the material, therefore, on a disclosure basis, there's nothing to disclose.
Yeah.
And the CAT says, well, you could have come up with this material. So that's not something that the CR could have asked for or compelled.
Well, it could have asked for it.
But it could have asked for it, because
it knew all along that we've been saying we don't have this data.
Yes.
So it could have asked for it right back when we were saying we don't have this stuff.
But it's not something a court could have ordered.
I think it could have done under
It could have done.
the CAT rules.
Oh, I see.
Yeah,
Under
I'm
the
not
CAT
sure.
rules, not ordinary civil procedure rules.
Well,
Okay.
I mean,
CAT has a power to order anything which is conducive, including, I think, the generation of evidence.
yeah, well, we've had in CAT proceedings a degree of flexibility about these things. So, for instance, there have been some cases where, in order to circumvent the need for disclosure, it's been ordered that you should provide a statement as to how, for instance, a cartel operated or how pricing operated. And those are measures that have been ordered by the tribunal. I don't think the tribunal has ever ordered anything of this sort. And the truth is that if it had been asked, if it had been raised by the class representative early on, you would have then had a debate as to whether or not that was really appropriate, for the reason that I adverted to. If the exercise you're arguing about is how you attribute costs when you haven't done it in the contemporaneous data, because that's the point. The data from 2015 through the claim period didn't include that breakdown. So you would be engaged in an exercise of attribution. And that's in a way what the tribunal ends up doing. So you might have had quite a fight about it. I'm not pretending it would have been straightforward. But the point is, if you know that the data you're going to get is not granular to the services that you're dealing with, then of course it's open to you to make those applications. I'm not saying that you grant it, but it's open to you. So in that regard, my lord, no, I think that is something that clearly could have been done because they were on notice. We didn't have that material. And this is why all these protestations are
Well, at the very least, even if whatever the cat's powers, and I rather suspect they do have the power, it was still within your power to change it, of your own discretion and volition, if you wanted to.
well,
You could have.
we could have done something. Yeah, I'm not denying that
No, no.
you
So-
could. You could.
So if it turns out, and I'm not going to put words into the cat's mouth, but if it turns out, as the cat said, you didn't and you could have done, and it then, well, I mean, it did in various paragraphs take that into account in evaluating the weight to be attached to the evidence.
Yeah, it did. I mean, that's the punchline in relation to all of this. Again, the fact that as I've already said, the fact that Ms. Kreisberger keeps referring to the fact that the cat took issue with this process doesn't help her case. It hinders it, because the cat was very much in mind about these sorts of issues. I mean, the same tribunal that managed the case management process, but we'll leave that one aside. But yeah, so even if she were to get traction on these points, which I am objecting to, even if she does, it doesn't help her overall in relation to ground one, because the cat coped. And not only did it cope, but it explained why it was doing what it was doing because of its concerns about these issues. And we don't have to accept those concerns. We don't have to be happy about the way the cat dealt with those issues. But for the purposes of today, it doesn't assist Ms. Kreisberger. So, as I say, there were numerous responses indicating this position. And I would just pick up one, which is at the core bundle, tab 29, 1321, which I think will be core bundle 4, I'm guessing. I'm sorry, I've been working on that.
Yeah. Sorry, the page is 1331.
Yes.
Yes.
It's something we've referred to in our written submissions.
Yes. In fact, we've been to this page already,
Yeah.
I think.
I just wanted to direct you to the final column here, which is our response. So when it says our response, this is the response of the class representative, just to be clear. So what's being said here is that we understand you can't provide that granularity of data, so this is how we're going to approach the matter. So they were recognising there were limitations on the data that we could provide. And as I say, we provided data and we provided disclosure material. It's referred to as unstructured, which makes it sound like someone tipped a truck of papers, but it wasn't. It just means that it wasn't drawn from spreadsheets. So there were all sorts of slide decks and correspondence and so on. So it might be thought it was orthodox disclosure. So they had that material as well. But the point is that this was an issue that was very much live through the whole process. And as I said, it was an expert-led disclosure process. And it's worth just picking this up. It's a document from the 22nd of July, and it's the Joint Expert Methodology Note.
Sorry, where are we?
That is actually just in the core bundle at tab 12, page 458. I'm just highlighting that to indicate and support the point that this was an expert-led disclosure process. Tab 52. I apologise, my notes from
Tab 52.
I'm told.
Yes.
So I'm sorry, let me cut through this. Let's just go back to core bundle 12, 458, the tribunal's order. Because I think that in many ways it covers the issue.
Yes.
I mean, it's transparent. You see, what you have there is the manifestation of the hands-on case management. And this is an order dated May 2022, talking about trying to agree the scope of issues, identify factual material, identify any gaps, seek to agree proposals to methodology, and so on. Seek to agree what, if any, disclosure of BT's data is required, and if so, the content, format, and extent of any disclosure. So when I was saying this was an expert-led process, the CAT was putting in place early a scheme to enable this. And the gaps table to which Ms. Kreisberger took you was effectively the product of that. That's the table where you have to do the massive amount of zooming in. So that was effectively a situation where the experts were getting together, they were talking about what was there, what wasn't, how this would fit with their methodologies. And the paragraphs to which Ms. Kreisberger took you just simply illustrated yet again that BT was explaining we didn't have that granularity of data in relation to those topics. Further point that was picked up by Ms. Kreisberger was just on Mr. Cackett. Variously described, I think, in the submissions as Delphic and now a bombshell. I leave you to work out the nature of the Delphic bombshell. But, in any event, Mr. Cackett's witness statement did explain, this is at paragraph 30, which is on page 1884, I think 5.
Yes.
So he had a whole section on how budgets worked. He was a high-level financial officer within BT, and he was talking about how budgets worked and how that fitted with pricing. And then it talks about particular sorts of costs, including SG&A, so that's selling general administrative costs. And these are the sorts of costs that are referred to as common costs often, or a large component of them, because they're shared costs across numerous products. So he's focusing on those common costs issues. And then if we go over the page, you'll see that he talks about examples. You know, staff in head office are a common cost here. Call centre staffings may be slightly different because it might depend on. But then 30, he says these indirect costs are recorded at consumer level, so this is division level, because they're not directly attributable to any particular division. Given the difficulties in attempting to attribute costs and the fact that these costs are not managed by individual divisions, we don't attempt to attribute these costs when creating the medium-term plan and budget. Instead, we consider and manage these consumer-wide basis as explained above. So this is essentially explaining why you have the data in the broad form that it is. But then he says, we do make some estimates of how these costs are spread across different divisions of BT Consumer when we create financial metrics known as unit economics. And that is the footnote, which says that's about individual products. But it's not hidden away anywhere. Although these unit economics are not created as part of the medium-term plan process, we use them to help us perform a sense check that across consumer we're likely to be making enough revenue to balance against our costs to meet the budget. So it was explained how BT did things, and of course Mr. Cackett, he was a custodian in relation to the disclosure, so all of the material that he held in relation to any of these exercises, that was disclosed. So again, it's not just that they had a vast amount of disclosure of data, which we accept was at a wider level, but they did have much more detailed material, and that was actually what came out in the course of cross-examination and re-examination, reference to some of the particular documents. And it was at that point and for the first time that this case was raised during trial, that somehow there was a whole different exercise that could have been done. So, as I say, what we had was a very sophisticated case management process. We had BT explaining what it was able to provide by disclosure, providing witness evidence, and providing extensive disclosure from those witnesses. And all of it was taken into account as relied on by the tribunal, and it wasn't happy entirely with these matters, but it took these issues into account, and that's why there's no issue of law here. But I wanted to take you through that because I wanted to explain how there is just not a fair representation of what was going on in relation to case management, and the idea that the tribunal should have grasped the nettle is just not fair. I won't go to the transcripts that were referred to in passing, but what actually happened in July 2023 was that effectively the expert for the class representative has presented the case, and the whole case had been pleaded, that there was an alleged overcharge just in relation to line rental. And the expert came along and said, no, actually we want to make it in relation to calls and line rental. And obviously that's a larger sum, and the quantum doubles, and you just say, BT said, well, hang on a minute, what's going on here? And actually the argument in that transcript was BT turning up and saying, you can't just amend like this unless you explain what your expert methodology is here. And Ms. Kreisberger said, well, we were very ready to accept that we would explain that expert methodology. But ironically, what was going on at that hearing was BT protesting he didn't understand what the class representative was doing with its amendments. And the order that emerged from that is just at page 466, tab 14 in the court manual. That's in court 2, thank you. You'll just see there that the claim form amendment is allowed, but on the basis at paragraph 6 that the claim form is then expanded to spell out on the part of the class representative what their expert methodology was going to be and how they were approaching these issues, given that it was quite a late change in the process. So it's very difficult to understand, and it feels a little bit Ministry of History to be suggested that somehow this was the BT holding back in relation to its methodology. So that's not what we're seeing in relation to any of these orders. So, as I say, nothing to see on case management, nothing to see in relation to an error of law at all here, and an unfair appraisal of the CAT's actual assessment in relation to ground 1. I'll briefly deal with ground 2, but I think the essence of ground 2 is there's no basis for an allegation of irrationality here. I think the terrible weapon of the broad axe was mentioned in passing somewhere earlier this morning.
I have a feeling it was used against you in the trucks case.
Oh, yes, it's wielded in so many ways. Yes, it was. But I'm not going to deal with broad axeness and exactly its parameters. But I think what we can say very clearly is that what we're talking about here is leaving aside artificial demands for precision and using assessment forensic skills to engage in reaching a solution. It's coping in these circumstances. I provide the reference. You will have it in mind from from this court's judgment in Gutman. So this is Authorities Bundle, page 318, paragraph 59. Broad axe is not so much a substantive principle of law as a description of a well-established judicial practice. And that's essentially what is going on in relation to the assessment of common costs. And therefore, the suggestion that somehow there is irrationality in the way in which these common costs were identified is just wrong. I've taken you to paragraph 904 in the judgment, where the experts for the class representative were saying these common costs they're nothing really, and the tribunal dismisses that. Then it looks at the various alternative methodologies, including looking at the law on combinatorial testing, considering the RFS materials, and I've taken you to the conclusions at 778 through to 780 in the judgment. And then you have the overall conclusions that are picked up at paragraph 897 through to 907 in the judgment. What that is doing is saying, yes, there are serious deficiencies in Dr. Jenkins' approach, but the common costs are real. We are going to use our expert assessment, having heard all of the evidence, to reach a conclusion. That is not irrational. And it's worth just bearing in mind that, as I say, tribunal had rejected the proposition explicitly that the common costs in BT Consumer were small or immaterial. It had accepted the principle that there should be flexibility in relation to the recovery of common costs. So that's in particular paragraphs 672, 675 and 745. And in those circumstances, using the idea that the class representatives benchmark, using the RFS, which didn't identify any common costs and gave zero flexibility in relation to their allocation, it was clearly taken into account, but it was not being dealt with on any sort of complementary basis, and instead a broader inquiry into common costs referring to Dr. Jenkins' materials was being used, and that was reasonable, rational and appropriate in all the circumstances, even if from BT's point of view the cat thought BT thought the cat was being harsh to Dr. Jenkins in those circumstances. And that really is the answer on ground two.
Which is good, because I think you've had your time.
Yes. Thanks. Yes, sorry, there is one very, very brief point on a point that Miss Kreisberger raised about paragraph 776 in the judgment about bundle synergies. With respect, in those circumstances, what the tribunal was doing was saying where you've got a situation where you've got line services on the one hand and bundle services including a line on the other, that actually one can draw from that, which was the subject of extensive evidence during the course of the hearing, the sense that there would be common costs between the two on an incremental basis. It was perfectly open to it because it had all of that material on both bundles and in relation to line rental, and in those circumstances there's no problem with paragraph 776.
There was an incremental cost to the SFV service over the bundled service.
Yeah, I'm not sure that that's exactly what 776 actually says. I don't think that is what 776 says, because, sorry, let me go to it. So 775 says the existence and prevalence of discounts for bundles over the standalone equivalent does indicate the existence of supply side synergies. In other words, you could do stuff together, and therefore it was likely you would be having common costs in relation to that, which are in turn likely to come from common costs. So it was drawing an inference from the evidence that it had before it. And then yeah, I'm not sure it's right to say that there's an incremental cost for SFV. I just think that's a misinterpretation of 776. That's not what's being said there. And the tribunal is very cautious. It says, look, we haven't got detailed evidence on this. This is a matter of principle. Again, as I was saying, it does some sense checks along the way. But I just wanted to point out that actually Ms. Kreisberger's reference to an incremental cost is not right in relation to 776. I'm grateful to Ms. Kreisberger. And second is the
Thank you very much, Mr. Beard. Ms. Kreisberg.
Thank you, my lord. If I might begin by going back to the RFS, Mr. Beard said, and this was one of his first points, to quote, the RFS didn't identify common costs at all. That's not quite right. If I could show you paragraph 516 of the judgment, internal page 128, the CAT set out a description based on Mr. Duckworth's evidence as to what the RFS in fact did. The first part of Principle 3 implies that where possible,
Sorry, where
Oh, I'm
yes,
so
I see. No,
sorry.
I have caught up. Yep, I'm with you.
516.
Yes.
I just started
Yes.
partway through the first line. Where possible, costs are attributed on a causal basis, so as to arrive at genuinely incremental costs. For non-incremental costs, which include genuinely common costs, they were to be attributed on a fair basis. The PAD does not give any further detail as to what the fair basis entailed. So it, as I said earlier, it doesn't split out common costs, but it certainly did attribute them, and it did so on the fair basis.
I'm sorry, I should be clear. All costs, including common costs, were covered by the RFS, so I'm not disputing that in the slightest.
Grateful for that. Now, staying with the RFS, point that perhaps I haven't brought out sufficiently is that when one is thinking about the adverse inference, Dr. Jenkins.
Sorry, could you move closer to
Oh, I'm so sorry. Dr. Jenkins flatly rejected the RFS. Now, that was unexpected. She conceded ultimately that the RFS were actual costs. Or that's not quite right. She said they weren't actual costs because they're not contemporaneous, which submission Mr. Beard echoed. But she said she didn't object to the basis on which they were allocated, but she objected to their use here. And she made no reference to them, Dr. Jenkins. She didn't perform. She performed other sense checks based on an Ofcom judgment and so on, but she didn't look at BT's own accounts. Now that, we say, should have been a red flag for the CAT. When your lordship asked me, well, what should the CAT have done? It should have said to itself, well, there's something rather curious here. The class representative relies on these accounts, but BT's expert doesn't. And in addition to that, the CAT carefully goes through the criticisms of the RFS and rejects them all the criticisms levied by Dr. Jenkins. So that should have been factored in to the adverse inference and the whole question of whether the CAT could cope with Dr. Jenkins' evidence. So that was a serious deficiency, along with the deficiencies that the CAT itself identified. Now, Mr. Beard also said that the CAT very clearly had in mind the RFS methodology. It certainly did analyse the methodology, and I took you to some of the passages. My submission is not that it somehow overlooked the RFS altogether, but it didn't place any reliance on the RFS in what I've called the operative part, where it conducts the assessment of common costs. It doesn't factor it in at all. It doesn't even use it as a sense check. Again, that's an indicator that the CAT couldn't cope with the Dr. Jenkins evidence. It simply took that evidence in a vacuum and made a downwards adjustment, both at ground 1 and ground 2 parts of the analysis, the extent of the common costs and the attribution, and it made the slight adjustments at each stage. But it didn't factor in the RFS. Then moving on to, I should just say on that last point, the coping mechanism as it relates to ground 2, was obviously inapt because the SAC combi was found by the CAT to be seriously deficient. So a downwards adjustment doesn't cope with its deficiency. A downwards adjustment is to enshrine that evidence into the assessment, the actual assessment of costs. It didn't cope, it relied. Now, Mr. Beard said a number of times that it was not, what they meant when they said it was not possible was it was not possible to simply disclose the common cost data. I'm not going to go back to the response from BT, but the wording was it won't be possible to break down. It won't be possible to break down the data by customer type.
And just to be clear, you don't suggest that there was material that could have been disclosed?
No, that's not not in terms of hard data. Of course, BT could have put forward a factual witness, a witness of fact, to speak to cost drivers.
No, I follow that, but in terms of an order for disclosure, it wouldn't have been within the scope of disclosure.
No, I agree with that. I agree with that. And to return to that point, to say that the class representative should have asked for it when BT didn't share the information with the class representative that it could be done, and it had told Ofcom that it could be done, and some informal allocations were in fact done. BT didn't share any of that information when the class representative said, can we have fully disaggregated data for SFV services? So it's a sort of cry for telepathy. I mean, parties are meant to engage constructively on disclosure issues. Now, Mr. Beard said that BT gave an enormous amount of disclosure. That is a submission which my learned friend made at trial frequently, and it was addressed by the CAT, and we have been there at paragraph 702. BT informed the CR that it did not have specific cost data for the SFE services. That's what we've been discussing. It's perfectly true that there was a very substantial amount of disclosure from BT on the question of costs. However, it was not suggested, nor could it be, that this opened the window, as it were, to indirect cost information that was specific to SFV services. Had it done so, no doubt, Dr. Jenkins would have availed herself of it. So BT's argument that the class rep somehow wrongly failed to make use of relevant disclosure does not hold water. And that's close to the submission I think we just heard. And the confidence of the CAT that Dr. Jenkins would have availed herself of it was she didn't ask for the data that the class representative requested that would have assisted her analysis. Again, another red flag for the adverse inference. Mr. Beard also said that BT put forward as witnesses a series of individuals who were closely involved with all the details, but they didn't disclose any details. There was no evidence about indirect cost drivers from a witness of fact. Then there was discussion about the late, Mr. Beard said there was a late change about calls and access. I do need to just flag that's not accurate. I'm not sure it's terribly material. But my point about the July CNC, and with respect the CAT's failure to grasp the nettle, is that the CR was properly directed to provide its full methodology, setting out the RFS, use of the RFS and all aspects of its methodology. No direction was given to BT. And my Lord Justice Green's judgment on the McLaren certification makes clear that in order for the CAT to be able to see where the problems are in relation to evidence, it's necessary to see both sets of methodologies. And we didn't have
As far
that.
as I remember McLaren, that's right.
And we didn't have that here. We were in the dark until September, and the defence didn't give much of a clue as to what they were going to do. So the CAT couldn't, to be fair, do anything about it, given that. But it could have. I think the failure was not to have an even-handed direction on methodologies.
But that, timing-wise, that doesn't sound so important. I mean, if the CMC was in July and you got the information in September, well, how much earlier would you have got it if there'd been a direction?
No, it's right that at that point one couldn't ask BT to do the full bespoke exercise. It was absolutely far too late for that. But what we would have known then is that Dr. Jenkins wasn't using the RFS, which, as I said, is the really strange feature of her evidence, which that alone raises the question of the adverse inference. I should just say that I didn't use the word fabrication. My submission is that her evidence indisputably gives rise to much greater figures than you see for indirect costs in the RFS. My last point is that I am conscious that I haven't addressed your lordships on ground 3, and as I said, it's fully addressed, but there is just one single point, which is that BT say in their submissions in response to ours that the point that there's an evidential burden at limb 2 on the defendant was never made at trial, and that's not right. I could give your lordships one reference for your note to take away.
Well,
But
either it is or it isn't.
to be clear that
But it does, I mean, we had this at length in the Sinvan Advents case about, I mean, if the information lies with one party and predominantly limb 2 evidence lies with a defendant who's trying to assert value, then if they don't produce it, the CR and the CAT is entitled to say, well, we've established cost plus. It is in excess of cost plus. Cost plus itself is sufficient in law on an United Brands basis to give rise to a breach. So you've met your burden. If the defendant then says, I've got X units of value, it puts forward its case, and then it's up to the CAT fairly, thoroughly, rigorously to investigate it.
that's precisely the point, my lord. And the only point I wanted to add, because it's in response to the written submissions, is that we made that precise point at trial. In oral closings, written closings.
It becomes something of an irrelevance when the defendant does put up evidence, it is examined, and then the CAT forms a conclusion about it.
Yes, but that evidence has to be quantified and correlated to the excess in your lordship's
Yep.
words in Sinvan. That's all I was going to say on that. Unless I can assist you further, my lords.
Thank you very much. Mr. Beard, is
No,
this in response to
it's only
the...
on that, you have the evidence material on that. Fabricated, Ms. Kreisberg used the term page 23, line 24. Like, if it was unintentional, I can
At any rate, it's not maintained, so we can ignore that. As I indicated at the start, we're not going to give judgment here and now. That means that you will get a draft in the normal way for you to correct our English and typing, but not so that you can re-argue the question. we'd be grateful if at that stage you would also seek to agree an order dealing with consequential matters. If there are points on which you disagree, could we please have brief written submissions, and we would expect to settle the points in the order that we make. Ms. Kreisberger.
Sorry, no, I
Yes.
don't mean to interrupt when you're not.
I was only finally going to stress what you will already know, which is the importance attached to the embargo. If you think of anybody else who ought to see the draft who doesn't already feature in any list, you obviously need to come back to us. But Ms. Kreisberger.
No, that's fine. I was just being prompted to mention that there is, of course, ground 4, but we weren't proposing to make submissions on that today beyond the written submissions.
Oh, yeah.
I'm grateful.
In which case, thank you all very much for your help.
Court rise is able.